something else that's going to be changing probably relatively soon. Just more governmental emphasis than ever before on how how workers are classified, either as employees or independent contractors. And even though that's more of an employment law issue, it certainly has ramifications on the employee benefit side. And just to give you some real hard and fast numbers here, as the slide indicates, just a couple of months ago, the IRS announced it's going to begin auditing. They specifically said up to 6,000 employers and focusing on this issue of whether the workers are being properly classified or not. So I hope that no one here in this room happens to be one of those employers that's picked for such examination, because I think it's going to be a pretty rigorous type of examination. But they're trying to catch employers that are pushing the envelope or going beyond the envelope in terms of classifying people as independent contractors that should be classified as employees, and therefore enough payroll taxes aren't being paid in then, because the independent contractor is obviously having to report a self-employment income, but the government has to wait for its money when that happens, and there's a lot of money that doesn't get reported at all if that's the case. So and I know that Illinois, for example, passed a state law that made some changes in this area. Wisconsin hasn't done so yet, but Obama, even when he was a senator, I think, announced an emphasis on his part to change the law in this area. Now, he's been busy doing other things, focused on other things until now, healthcare reform, and now financial reform of the financial industry. But I think it's likely that at some point along the way there may be something that the administration is maybe pushing to change the law in this area too, to actually change the rules for how what the factors are that employers use to determine whether someone's an employee or an independent contractor or not. So far that law hasn't changed yet, but it's something for everyone in this room to be more aware of, and it's not just the IRS, but the Department of Labor too. In their most recent proposed budget, is hiring a lot of investigators to go out and target employers who misclassify their employees. So it's not just an IRS or tax issue. So another point I want to make here too: if you go to the IRS website and just Google some of these terminology like employee classification or misclassification, you'll see that the IRS looks like it's moving away slightly from the old 20-factor test that you may have heard about, 20 factors, and if more of them point toward employee status, then the person should be an employee. And there's sort of more 3 general categories of things to look at having to do with control. And I won't get into the details there because we could talk for a long time about this whole subject. But if you're interested in this subject of classification and wanting to know, what factors should I be looking at here, if you have someone who works for you and trying to find out how should they be classified, I would encourage you to go to the IRS website and see how the IRS is, what kind of guidance they're giving to employers these days on that subject, because it has changed a little bit, even though the law itself hasn't changed yet. And then this slide just sets forth kind of an obvious point. I mean, if you do have, in general, if an employee or a worker, let's say, is classified by you as an independent contractor, but then reclassified as an employee by a government agency like the IRS or court, in general, that means that that person is now entitled to, or maybe should have been before, entitled to certain employee benefits, like maybe participation in the 401k plan. So unless you do something that we've been doing for a while with the 401k plans that we are responsible for, and putting specific language in the document along the lines of what I have on this slide here, which says, even if as long as you, the employer, have classified someone as an independent contractor, given them a 1099, not a W-2 form, then even if they are reclassified later on by a court or a governmental agency as being an employee, they're still not entitled to the benefits from the plan because we've specifically excluded them. You can legitimately do that. We put that kind of language in the plan, the 401k plan documents that we draft for our clients as additional protection to the employers. But if you don't have that kind of language in there, then, and you have a reclassification of a worker to being an employee, retroactive, because usually the IRS is always a couple of years behind the fact. They may be auditing now for, say, 2008 or even 2007, do a reclassification back, get payroll taxes back. The employee's natural, if they're well advised, will be coming back and saying, hey, wait a minute, if I really was an employee, should have been an employee 2 years ago, I should have been entitled to participate in your 401k plan 2 years ago and get the matching contributions you would have been paying in for me too, so pay them in, you know, and make me whole. And in fact, that's how the government would view it too. And it would be viewed really the same as if you'd had someone who was an employee and you'd forgotten to enroll them in the plan on a timely basis. So unless you have this kind of language in your plan to protect you, you could have, you know, a serious, seriously large amount of kind of a corrective contribution you might have to make as an employer to the 401k plan for one of these reclassified workers. Same kind of impact on the health plan side as I just talked about with the 401k.
Or life insurance, for that matter. That would be a big one.
You know, arguably, it's quite right that if someone is reclassified as an employee, you know, retroactively, they should have been entitled to the health insurance coverage. I think it's maybe not quite as big of an issue, just because if they weren't, you know, the fact that they weren't getting health insurance, that they may have to be put on the health plan from that point going forward. It's a little hard to put someone on a health plan in a retroactive basis. It's easier to put someone in the 401k plan because it's just a matter, retroactively, so to speak, because it's just a matter of dollars. Pay the dollars now to kind of make them whole, as if the dollars had gone in on a timely basis. But with health plan coverage, the way it just kind of works on a month-by-month basis, I think it's kind of hard. You can't really put them in retroactively. Now, arguably, you could pay them something to compensate them for the, let's say, the value of the coverage that they should have had but didn't get. But
yeah. Right.
I think from an insured plan standpoint, I think the insurance companies would pretty easily be able to say, you know, fight such a claim, because even though the person should have been in the plan, they weren't. We as the insurer are only obligated to pay claims for people that are actually under the policy, and if they're added later on, that doesn't. You know, there's a limit to how far retroactive you can go, and I just don't think. From an insurance company standpoint, you really can't go retroactive at all, maybe more than perhaps a month or two. I think there's usually a little bit of a time lag sometimes too from the time that you're allowed, just sometimes in a COBRA situation, sometimes in other situations where the employer might say, oh, this person really was on the plan, you know, at the beginning of last month. You can do a little bit of that, but
if the employee sued you as the plan sponsor under ARRA, saying you should have put me in the plan 5 years ago, and if you would have, then my $500,000 hospital claim last month would have been paid for by the health insurance. Insurance company won't pay for it, but you could be held liable for it, right?
That's quite true. I haven't seen a case like that. I haven't seen
them either.
But I think it may only be a matter of time before such a lawsuit is filed. So it's a good point, and it could well happen.
Errors and omissions coverage.
Yeah.
Maybe, I don't know, fiduciary liability insurance coverage would, I think, cover something like that or not.
I agree with Tim that probably the best protection for the employer is just to have good insurance protection. You know, like the employers can get insurance protection against, you know, employee claims, and also insurance protection against, you know, ERISA fiduciary liability. So if you
also that same language we have that we put in our retirement plans about subsequent reclassification by a court or the IRS, you could put that in your health plan or in any benefit plan, right?
You could, although with an insured plan, of course the main language of the plan is what's in the insurance policy, and I'm not sure how
maybe
easy.
Maybe
in a wrap document. Yeah, that's the subject for another day too. It's kind of, you can do employer can do wrap documents, plan documents that kind of wrap around the insured plans and provide additional provisions that may be important to the employer but not important to the insurer, and this might be an example of that. Question? Meant that some health insurers will allow you to affirmatively cover independent contractors, but and that I think that's true. Keep in mind, though, that, you know, providing a benefit like that to an independent contractor is certainly one of the factors that even the IRS is going to look at in determining whether or not they're an employee versus an independent contractor. So as a lawyer advising an employer, I would caution an employer to be very careful before they even make the decision to provide a benefit as important and valuable as health insurance to an independent contractor, and why not just make that person an employee and provide them the same coverage as an employee? I mean, so it's a good point, but it raises some other issues that I would want an employer to think about before deciding to do that.